Okay. Hey, everybody. Had a little problem there going live. Um, yeah. All right. Okay. Got a lot to cover. It's been a while since I've made some videos and some live streams. Think I'm getting a little echo. Let me see what my situation is here. Okay, let me test. Okay, we're good. All right. No, I'm still getting an echo. Give me just a second. Are you guys hearing an echo or hearing me at all? You can type something in the chat. Okay. What does 5 by 5 mean? I see you fine here. Can you hear me okay? Sounds good to me. Okay, that's good. I'm getting some kind of echo. I'm gonna try to just let's see. Let me turn down my volume. Okay, that did it for me. Okay, so hoping you can still hear me. I think we're fine. Okay, lot to cover here. Quick intro, then we're just gonna jump right into the material. So, and this will apply to you if you're in Louisiana, and most of it will apply to you wherever you live. So we got a lot of good information to share. Um, all right. All right. Funny, right? Thanks. So yeah, feel free to you subscribers can feel free to throw in your comments or your questions. Of course, we want to keep everything positive and clean and all that. So Louisiana Estate Planning 101, Wills, Trust, and Succession Explained. My name is Paul Rabelais. I've been an estate planning attorney for a very long time, decades. I've written a book and I've revised it over the years. Here's the 2025 version of my book, Estate Planning in Louisiana. So a lot of the things that I'm going to talk about here this evening they're all, in my book. My book is written for the kind of layman consumer, so get a lot of good feedback on that. All right, so and just as a quick note, kind of our estate planning law firm leverages that deep knowledge of Louisiana's unique laws, and we've extended our expertise to clients across the country after recruiting and collaborating with our network of co-counsel attorneys in other states. So this approach that we have allows seamless and consistent coordination, ensuring that clients receive well-rounded legal support tailored to their specific needs, regardless of their location. All right, let's jump in. The way I want to approach this is I want to talk about what people's typical estate planning concerns are. What keeps some people awake at night? What do they worry about? What do they want to make sure they address if and when they talk to an estate planning attorney? We'll talk about all those typical estate planning concerns. Maybe you can chime in with additional concerns that you may have, or maybe you can confirm that some of the concerns that I expressed that most people have, maybe you have those concerns as well. Love to hear it in the comments. And then I'm going to jump right into an example of a married couple with some children, with some grandchildren, and I'll go over what their assets are and then we'll start talking about well what happens if they do no estate planning, but then we'll really jump in and dive into the planning that they do and that perhaps their lawyer guides them through, and that's where the meat of the conversation and the content takes place. Okay, and then we'll actually wind up with kind of all of the elements of their estate plan. So let's just jump right in. All right, people's typical estate planning concerns, and look, I have had thousands of estate planning meetings with people really all over the country, and the reason I've talked to people all over the country is I started this YouTube channel 8 or 9 years ago, and it got pretty popular, 300,000 plus subscribers, and so people started contacting me from all over the country. Paul, hey, can you help? So I've talked to people all over the country, not just in my home state of Louisiana. And so one of the first things I do when I talk to people is I say something like, what I'd love to hear is what's on your mind that you want to make sure we address before I start asking a bunch of questions and kind of guiding you through the estate planning process here. And so People typically tell me, a variety, one or more of the following 6 or 7 things as to kind of what's on their mind that they'd like to accomplish as part of their estate planning, and I'm kind of envisioning maybe this couple who's maybe 60, 65 years old. They've acquired some assets, maybe still working, maybe retired, and so it's now, they're in kind of serious mode. They realize they're not getting any younger, and they want to get all their legal affairs in order. So I ask them, "Hey, what are you worried about? What kind of keeps you up at night, if anything keeps you up at night, or what do you want to make sure we address?" So here's some things people say. Well, number one, they say, I want to make sure things are simple for my survivors, and maybe they'll follow that up with, I don't want to leave a big mess for my wife or my spouse, or I don't want to leave a mess for my kids. Maybe they'll chime in. Our kids live out of state. We're here. We don't leave a big mess with them. They're busy. They're trying to raise their kids. Some people say, my mother died 4 years ago, and we're just wrapping up her estate, and it was kind of a mess, and I want to try to simplify all of that. So one of the things people want to do in general is they want to keep things simple. Number two, and this applies again for people all over the country. Some people say, I want to make sure my spouse or my children or my grandchildren are financially secure. So there's a lot in that statement. So there's a lot on that. I want to make sure my spouse is financially secure. So does that mean you leave all of the assets to or for your spouse? And if you do you leave them to your spouse so they own it, or do you leave it in a trust for them so they can kind of use it and have access to it, but you dictate where those assets go when your spouse later dies? Same thing with the children. You wanna make sure they're financially secure. Do you give it to them in a lump sum? Do you give it to them so it's kind of doled out to them over time, and there's a million different options there? Do you wanna provide something for your grandchildren? Do you wanna carve out something for the grandchildren so you ensure that they have enough for their, college education, where costs are rising and rising? So that's the wanna make sure my surviving family members are financially secure discussion that we'll get into. Number 3, some people say, I just want everything to be fair. So, for example, talk to an individual today. He wants things to be fair for his children, but fair doesn't always mean equal. In fact, in this case, with the person that I talked to today, this person had donated or given, 6 figures to one of their children, during this individual's lifetime. And so they wanted to make sure that their other children who didn't receive any of these donations during this individual's lifetime, they got that 6 figure inheritance kind of off the top before things were divided 3 ways. So there's fair and there's equal. Sometimes that is the same thing, and sometimes fair and equal is completely different. So, but people want to be fair. Other things that we hear, sometimes we hear people say, I want to avoid family disputes. And maybe it's because there's a problem child, for lack of a better term, who parents know are going to cause a problem. But it's even more so when we talk about this, want to make sure that disputes are avoided. Parents are often concerned that their children's spouses will influence their spouse into causing problems. So there's a whole discussion there on how can things be set up to avoid family disputes. And then another common issue people bring up at the start of this estate planning conversation revolves taxes. People say, I've been paying taxes over my whole lifetime. I'd love to see us set things up so that the tax impact to my spouse, to my children, to my grandchildren is minimized. How can we do that? So we'll have a discussion about taxes. All right. And then another issue is where people say, I want to make sure that I select the right people to have control over things in the future if I'm not in control or when I pass away, because you do have to designate people to handle things at different times. So some parents some people come into the conversation kind of very specific about who's going to be in charge in the future. We'll talk about that. And then there's just a variety of unusual, maybe unusual is not the right word, or unique circumstances that we have to address. But maybe those circumstances aren't in every family. But we do see a lot of the blended family circumstance, Paul. I'm in my second marriage. I have 2 children from my first marriage. My spouse has 3 children from their first marriage. Maybe or maybe not, they had children together after they married, but that presents a whole set of unique estate planning circumstances. So we have to talk about that. And then there's also some other unique circumstance. Met with a a couple today, and they have children, and one has a set of unique circumstances. Another child is very young, and just another child's not real good with money. So we had to address the okay, after both parents pass away, these millions of dollars that the children are going to inherit, should it be left to them in a lump sum? Should it be left to them and managed by another individual or company so that it's managed properly, doled out over time? So there's a lot of circumstances there when parents feel like it's not in the best interest of the children to just kind of dump money into their children's lap in a lump sum. And then sometimes people say, well, the first thing on my mind, Paul, is I have this unique asset and I want to make sure it's handled the certain way. So that might be a family business. It might be a piece of land. With the conversation that I had today, it was a particular vacation property that we had to handle very uniquely in the parents' estate plan because they want that vacation property to stay in the family for years after the parents pass away. So that's a mouthful. And look, there's no limit to the potential primary concerns that people have. I remember one of my favorite people that I worked with was had a net worth in the tens of millions of dollars. So normally, that person comes in and the lawyer wants to focus on the taxes, or the lawyer wants to focus on whether there's going to be a trust company to manage all of these assets one day. But I forced this gentleman to tell me what he wanted to make sure he accomplished. And with his tens of millions of dollars that he sat on, he said, Paul, I have really one main concern. He said, I want to make sure that my grandson inherits my Ford Mustang. That's what I want. So really, we spent, unfortunately or unfortunately, we spent about half of our time together talking about how important it was to him that his grandchild inherit his Ford Mustang. Sure, we got to the tens of millions of dollars. Sure, we got to how the grandchildren were going to inherit, who's going to be in charge. But he left that day knowing that his most important issue of making sure that his grandson would inherit his Ford Mustang, he left that day absolutely certain, because we harped on that so much because that's what he wanted to do. So everybody's different, every family's unique. Okay, so those are some of the typical concerns that people have. And look, I'll get to some of those questions here in a minute, but let me get through the material and then I'll jump over and address all the appropriate questions. So now what I want to do is talk about kind of a hypothetical couple, like a case study. And so, given this is a kind of Louisiana wills, trust, and successions, let's go with a few Louisiana names. Let's call the husband and the wife Pierre and Lucille. They have 3 children. They have 3 grandchildren. Their children are all grown. Their grandchildren are still young. One of their children, their son, is Claude. I'll get to Claude in a minute because Claude's kind of the responsible one, and they're going to impose some duties on Claude. So that's their children, Pierre and Lucille. Let's say they're 65 to 70 years old. They've accumulated assets, and so they told me that their, kind of their net worth was about $5 million, consisted of an IRA worth $1.5 million, consisted of their home worth $750,000. They had a piece of rental property that was worth $500,000. They had a stock portfolio outside of their IRA that was worth $2 million. And they had some cash and miscellaneous other stuff worth about $250,000. Add it all up is about a $5 million net worth between the two of them. Okay. And so he kind of asked, he's like, oh, by the way, Paul, we've never done this before. We've never signed a will. We've never had a trust. We're not even really sure what a trust is. I hear we're supposed to have a power of attorney. Don't really know what that is. Never had one before. What would happen if we just did nothing and never came to somebody like you, or never talked to somebody like you? And so, kind of went through the basics of that. I said, well, if during your lifetime Pierre, you become incapacitated, you have a stroke, an illness or injury, you're incapacitated, maybe you get dementia, who knows, and you're not able to manage your money, you're not able to sign your name. Well, if a transaction on your behalf is necessary, then somebody's going to have to go through a court proceeding. They're going to hire lawyers and go through what is really a nightmare proceeding. Sometimes it's called a guardianship. Sometimes it's called an interdiction. And so it's a court proceeding where when someone is alive and they're unable to transact for themselves and a transaction is necessary, then the surviving family members are left no choice but to go through this court proceeding. Takes months. It's expensive. It's no fun for anybody. A judge has to appoint a lawyer for the incapacitated person like Claude because he has to have a lawyer. There's all kinds of court hearings. And so, but that's necessary. Let's say, for example, Claude has his $1.5 million IRA and he becomes incapacitated, gets in a car wreck, has dementia, gets a stroke, whatever. Now there's nobody who can sign and transact that IRA on Claude's behalf. Of course, it's in Claude's name. All IRAs must be in an individual's name. There's no joint IRAs. And so now they're stuck because they can't get money out of Claude's IRA. Got to go through the court proceeding. So we'll come back. So that would happen if Claude becomes incapable, and then let's say Claude dies a couple of years later. So now it's the state law that governs how things go. And first thing that's going to happen is there's going to be what many people call a probate, but in Louisiana is often referred to as a succession. So everything that's in Claude's name is frozen. Yes, Claude may have designated beneficiaries on his IRA, but realize he also had a home and a rental property and a stock brokerage account. So those are frozen. And a court proceeding now is necessary. A judge will appoint what's called an administrator. Lists of assets will have to be prepared, and state law will govern what happens to, let's say, Claude's $2.5 million or so, because Claude and his wife, what did I have as her name, Lucille, they own this $5 million as community property. So the courts would govern what happens to Claude's $2.5 million. Lucille would keep her $2.5 million. So it would probably go not as Pierre would have wanted, because the laws, at least in Louisiana, that apply when someone is married and they die without a will is now Lucille, for example, she can't sell the house. She can't sell other assets without getting all of Claude's children's permission. Lucille's like, that's too much of a burden. I want, Pierre and I built this up together. If I want to be able to sell my house, I want to be able to sell my house. I shouldn't have to go get my children's permission. So some of those things apply if someone dies without a will. So we're not here to talk to. And then if Lucille gets incapacitated in her later years, same thing, guardianship proceeding. Then when Lucille dies, the kids are all in court together, lawyers involved, going through a court proceeding, and the state governs who inherits from Lucille. So that's what happens if Claude and Lucille do nothing. Now let's jump into. They want to make sure they get things addressed, and they expressed all of their concerns, and many of the concerns are what I mentioned earlier. They want to make things simple for their survivors. They want to make sure their spouse and their children and their grandchildren are financially secure. They want to be fair. They want to avoid family disputes. They want to minimize taxes and expenses. So they want to give the right people control. So me or whoever is guiding them should start asking them some questions. And I might say, for example, all right, so since we're going to be proactive here and get things set up exactly how you want, Pierre and Lucille, what I like to do is I like to start with, let's say you've both passed away, and then we'll work our way backwards. So you've both passed away means the unlikely event that you both pass away at the same time, but it also means one of you passes away and then the other of you passes away months or years later, which is the likely scenario. So it doesn't matter. We can kind of answer. This starts the conversation and gets things where we want them to be. So that's often the first question with married couples is, what do you want to happen after both of you pass away? And so maybe the first item that comes up is, do we want things to be equal to our three children? And for most couples, they say, yeah. Although there was the individual I talked to today who had given one of his children some money during the child's lifetime, so the other children are going to get some funds off the top, because the other child got funds during their lifetime. So what do you want to happen after both of you pass away? Many people say we want it to be equal. All right. So then there's another conversation, maybe, about, and this depends on the age of the children, the financial maturity of the children, and a few other things that I'll address here in a minute. But then there's a conversation of, okay, so you have the $5 million, you want it all to go to your three children equally, whatever you have when you both pass away. Do you want it to go them in a lump sum where they get their 1/3, they can do what they want to with it? parents are like, "Yeah, that's exactly what we want." Or do you want, um, one or all or more of the children's share? May do we need to have a discussion about whether it should go into a trust or some or all of their share should go into a trust and have it managed for them by someone else and have it doled out to them over time? And so some people say, "Well, why would we want that?" Or they don't say, "Why would we want that?" But sometimes they say, "No, we don't need it," or, "Yeah, I think that's a good idea, Paul, and here's the reasons why." And those reasons why are, we have a child that just, not real financially secure, and we feel like if a child inherits $2,000,000 and they're, 35 years old, that $2,000,000 or whatever it may could have grown to, it may not be around to help them out when they need it, later in their life. So sometimes we hear that. So people are receptive to the, "Yeah, let's put that portion in a trust for them." Some people tell me, "Yeah, I think having it managed in a trust after we pass away is appropriate." And they'll say, "Because of my child's spouse. My child's spouse spends a lot of money. And if my child inherits $2,000,000, I know my child's spouse is going to influence my child into going and buying boats and cars and trucks and vacation properties and just a lot of stuff that I really would not like to see, happen." So, so there is that discussion. Do you want it to leave it to them in a lump sum, or do you want it to leave it to them in a trust? Oftentimes, by leaving $5,000,000 to 3 children, and look, Pierre and Lucille have $5,000,000 right now, and they're 65 years old. Maybe when they the survivor of them passes away, and that survivor is 85 or 90 years old, maybe what is now $5,000,000 might be 10 or $15,000,000 or more or less. So, so even if parents are comfortable just leaving it to the children in a lump sum, then we have another sub conversation about that. Okay, you just want to leave it to them in their name, and if leave Claude his one third, and let's say that's $4,000,000 when you both pass away, he can do whatever he wants to do with it, and the moment he gets it, it's just his. But if he mixes any of that inheritance up with other assets Claude has with his spouse or his wife, and later gets divorced, then Claude may lose a big chunk of his inheritance. So let's have the conversation about whether you'd want to leave, even though you don't want to put any restrictions on Claude. Do you want to leave Claude or all of your children's inheritance? But I'm picking on Claude now. You want to leave Claude's inheritance to what I call the Claude Trust. And that way, all of Claude's inheritance for the rest of Claude's lifetime will be titled in the name of the Claude Trust. Claude as trustee of the Claude Trust. So the brokerage accounts and the investment accounts for all the investments will be titled after the parents die in the name of the Claude Trust. And that can make it harder for Claude to commingle or mix up those inherited assets with other assets Claude may have with his wife. So if Claude does subsequently get divorced, Claude keeps his trust, all of his trust, and then Claude and his wife split other assets that Claude and his wife accumulated during the marriage. So if you're going to go yeah, let's leave it to them in a lump sum. We don't want to put any restrictions on them. It's, do you just leave it to them in their name, or do you leave it to them in a trust for them to make it more divorce proof? Now, if a parent says, "No, I think we better have it managed for them by someone else," then there's lots of discussions about, okay, so who's going to be the trustee and who is going to manage it for them and dole it out? Is it going to be another individual? Is it going to be a corporate trust company? So there's conversations about that, and then there's also conversations about when will those assets be doled out to the children. So recently met with a couple, and their children are adults, and so they said, "Well, we'd feel comfortable giving them a third of their inheritance after we both pass away, but the other two thirds, we don't want them making a big mistake with the entire amount." So they said 7 years after we pass away, let's have a trustee dole out another third to them, and then 7 years later, they can get the rest of it. So it's all a personal preference. I'm never the one who makes those decisions. My job is really to give you all those options and kind of guide you through and let you make some informed decisions. So After both Pierre and Lucille pass away, let's say they decided that um, they didn't need any kind of management of the inheritance for the children, but they did like the idea of leaving the children's inheritance to each child's what I'll call inheritance trust to make it a little more divorce proof. Like a lot of parents say, we really like our son in law, we really like our daughters in law. And then there's the old saying that everybody says, but you just never know. So that's what's going on after both Pierre and Lucille pass away. By the way, Pierre and Lucille have grandchildren. So I asked the question, do you want to leave it all to your three children, or do you want to kind of carve something out for the grandchildren? And so we get a lot of different answers to that. Some people say, well, yeah, let's leave, 75% to our children and 25% to be divided among our grandchildren. Some people say, I just want to acknowledge the grandchildren. So let's leave, $50,000 to each grandchildren when we both pass away, and then we'll leave the rest of it to our three children equally. And then, so there's examples like that. And then if the grandchildren are young, really same discussion there. And what we often do, let's say those grandchildren are 1, 2, and 3 years old, Pierre and Lucille's grandchildren. And let's just say, for example, each of Pierre and Lucille's three children, each one of those has one child, so three grandchildren. So, like Claude has a child, Claude is Pierre and Lucille's son. So, the $50,000 or the percentage of the estate or whatever it might be that's left to Claude's child is left to a trust for Claude's child with Claude as the trustee. Again, this doesn't take any effect until Pierre and Lucille both pass away. But a lot of grandparents who want to leave an inheritance to young grandchildren will leave it to a trust for the young grandchildren and name the parent of the grandchild as the trustee. And then there's a few decisions there on when the grandchildren can control things. But Pierre and Lucille said, no, what we'll do is we'll just leave everything to our three children, and our three children we expect they'll take care of their own children. We don't want to carve out anything specifically to go straight to the grandchildren. Would be okay if they did, but that was just their decision. Okay, so that's some of the what happens after both spouses pass away. One more important decision there is I'll tell Pierre and Lucille, hey, you've got to appoint somebody to be in charge of making sure things get divided up three ways after you both pass away. Who's going to be that person who perhaps sells your house so the proceeds can be divided up three ways? Who's that person who will work with your brokerage company to make sure things get divided up three ways? Some people think that they don't have to name anybody, but you do. You have to have, we'll get to the terminology later, but either an executor or a trustee, depending upon the path we go down, to make sure things go to the heirs or beneficiaries in the way that they're supposed to. Now, I will say, as an asterisk to that, is if Pierre has a $1.5 million IRA, names his wife Lucille as the beneficiary, and now it's Lucille's IRA, and then Lucille dies, and she had named her three kids as the beneficiaries. There's no intermediator there. So that money, because IRAs have designated beneficiaries, the financial institution will just set up the three inherited IRA accounts for each of the three children and transfer the assets directly from Lucille's IRA into the three inherited IRAs. No executor or trustee would be involved in that. All right, so that's the what happens after Pierre and Lucille pass away, and really some of those conversations that we typically have. Now let's go back to what happens when maybe it's one, maybe Pierre dies and Lucille is still alive and kicking. Good for Lucille. Most men think they're going to die first, either because they're a little older than their wife, not always the case, or because they're a man and the mortality tables tend to say that males die, that males don't live as long as females. But whatever. It just I've had thousands and thousands of these conversations, and it's always there are exceptions. It's always the husband or the man who thinks he's going to die first. Okay, so let's talk about that. What if one of them dies? There's different ways to leave things to the surviving spouse. Again, we'll try to keep things simple. Pierre and Lucille have $5 million. They live in Louisiana, a community property state. Each one has 2.5 million. It's not really like that because Pierre has his $1.5 million IRA, but I'm going to disregard that for now. Let's keep things simple. Pierre and Lucille have $5 million. So Pierre dies, And so, how what happens to Pierre's $2.5 million dollars when he dies predeceasing Lucy? So he's got some options. I'm gonna say he's got maybe 4 options. So I'd say the least common option is Pierre, but it happens. Pierre leaves some or all of that $2.5 million dollars directly to his children because he might say, "Well, Lucille's got her 2.5 million and she'll be good, so I'm gonna leave my 2.5 million to my children." That's not common because you'll see some of the other examples, but, sometimes you see parents say, "If I die first, I don't want my kids to have to wait until my surviving spouse dies, my surviving spouse my children to get something when I pass away." So sometimes you see that. Not real common, but makes sense, and people do that. Option number 2 is a Louisiana-only term, but very common in Louisiana, and in Louisiana only is Pierre leaves Lucille the usufruct. You might say, "Never heard that before." USUFRUCT. It's a very common form of ownership in Louisiana, but people outside of Louisiana, never heard of it. But, it's really common in Louisiana because actually if Pierre died with no estate planning, with no will, then Lucille would inherit what's called the usufruct. Let's just call it use for now. The usufruct of his $2.5 million dollars. So sometimes people with a will, sometimes Pierre does leave the usufruct of his estate to Lucille. So now Lucille owns her $2.5 million dollars. She has the usufruct of Pierre's $2.5 million dollars. And when Lucille dies, the way Pierre structured it, if he gave her usufruct, he had said that usufruct lasts for her lifetime. And so when Lucille later dies, those assets over which she has usufruct revert back to, in Pierre's case, his children, who were called the naked owners when Pierre died. They inherited Pierre's $2.5 million dollars subject to Lucille's usufruct. So sometimes in Louisiana, you see people write wills leaving surviving spouses the usufruct of their estate or a portion of their estate or certain assets. That's the second thing Pierre could do of 4. The third thing Pierre could do is just leave his $2.5 million dollars straight to Lucille. You see that sometimes, where Pierre says, "No, if I die first, I want all of my part to go to Lucille." And Pierre might even recognize that by Pierre leaving ownership of his $2.5 million dollars to Lucille would then have her $2.5 million dollars, and she would also own Pierre's $2.5 million dollars. She would own the whole shooting match, and the potential there is, um, with one signature, Lucille could disinherit the kids. But like a couple I talked to today, they were like, "I have no concern that my surviving spouse would, leave things to anybody other than our children." So they were actually very comfortable leaving that ownership to the surviving spouse. So that's the third way, leaving ownership to the spouse. And then there's a fourth way that does offer more protection for the children, applicable all over the country, where Pierre says, "If I predecease Lucille, my $2.5 million dollars," Pierre says, "I'm going to leave it to a trust. I'm going to name Lucille as the trustee of that trust. She can take distributions of from that trust if she needs them. But then when Lucille later dies, what's left out of that trust reverts back to my children." So again, another way to provide for your spouse, but also provide some protection for your children to inherit the assets after the surviving spouse passes away. So there's those kinds of conversations that are necessary so that what you want to happen happens if you're married and you pass away before your spouse. So those are really those conversations are often overlooked, but they shouldn't be. So kind of an oh by the way, and I keep saying oh by the way because IRAs are treated differently. If Pierre has his $1.5 million IRA and he named on his designated beneficiary form, you wanted 100% to go to Lucille as the primary beneficiary. Doesn't matter what any kind of will or trust says, that's going to go outright to Lucille. And so you always have to remember that the IRAs they always go to whoever is designated as the beneficiary on that beneficiary designation form that's on file with the financial services company. So just always keep in mind there. All right, I will tell you what a couple I did today. I've been working with did was they did have some um, some family vacation property, and they wanted the children to be able to really enjoy that after the parents passed away. So that was going to be kind of, and we do this often. That asset is going to be carved out when the parents pass away and go into, I'm going to call it a special vacation property trust, and maybe one or two of the children will be the trustees of that trust. And so what the parents did, where they're like, man, it costs money to maintain that vacation property. So the parents are leaving the vacation property to the vacation property trust. And then they're also leaving $200,000 to their vacation property trust so that child or children who will be the trustee or co-trustees of that trust will have a pool of money to be able to pay for the ongoing kind of administrative and management expenses so that the children can always enjoy that condo without anybody having to come out of pocket to pay any kind of management and ongoing expenses. So there's that issue. I brought that up. Okay. So we've talked about what happens after they both pass away. Pierre and Lucille leaving everything to the Children's Inheritance Trust. They named Claude as the trustee to handle all of that after they both pass away. They, let's say they said, there's no way our surviving spouse would alter our plans, so let's leave ownership to the surviving spouse, which, by the way, is likely the best tax scenario because everything will wind up in the surviving spouse's estate, and everything will get a step up in basis when the surviving spouse dies. More on that when we talk about the capital gains tax in a minute. All right. So, and then we had a conversation. I was like, let me sidetrack for a minute and talk about some of these power of attorney issues. So we talked about that before in the video, and I would ask Claude and Lucille, who do you want to be able to manage all of your money if at some point during the rest of your lifetime you can't handle it for yourselves? And I said, most people name their spouse first, but you should also name a backup to your spouse in case you get to a point where you can't sign things and your spouse is unavailable to act for you. So they were both in complete agreement, pretty quickly answered, yeah, we want our spouse first. And then we want Claude, our son, who's really responsible, lives in town. He's a CPA, or they'll give me all the reasons why he's so responsible. And he's going to be the backup to our spouse on both our kind of financial power of attorney and our healthcare power of attorney, is what we call it in Louisiana. Other states call it a healthcare directive, healthcare proxy, advanced healthcare directive. Every state has their own unique term for what they call this. Okay, so now we've addressed the what happens if they become incapable, easy for their trusted family members to be able to make decisions, make financial decisions, make medical decisions, go get medical records. We've structured things so what they want to happen when one of them passes away happens, which is the surviving spouse stays in complete control of everything. We've talked about what happens after they both pass away. Claude oversees the third transfer to each of the children's inheritance trust to make it somewhat divorce proof or as much as we can without restricting the children in any way from being able to do what they want to with their inheritance. And so that's where we are now. Maybe the next big issue is, um, how do they do this? What's the logistics? How does it get all set up? Is there wills? Is there trusts? What are the legal documents? So at some point, there needs to be a discussion with Pierre and Lucille, and that discussion goes, and really this is the same discussion we have with people all over the country. Hey, Pierre and Lucille, two ways to do all of this stuff that we've been talking about. One way is you can leave everything in your name and you can leave things to your spouse and kids through your will. And most people get that. Wills are the traditional way this kind of stuff has been done. For example, Pierre might have a will that says if I pass away before Lucille, I leave my estate to Lucille. And then Pierre's will also says if Lucille dies before me, then when I die, I leave my assets to my children and trust for them, clause the executor. And so we had a conversation about if they were to do it that way, then let's say Pierre dies first, assets that are in Pierre's name will be frozen. Lucille will have to get back with lawyers, go through a court proceeding. Claude's will has to be presented to a judge. The judge has to declare that the will is valid, sign court orders, list of assets are filed with the court, and then a judge in a very kind of kind of burdensome proceeding. A judge has to sign various court orders ordering that the financial institution, the Department of Motor Vehicles, other people, a judge signs court orders ordering that assets be transferred out of Pierre's name and into Lucille's name. And so that proceeding, commonly referred to as probate in Louisiana, we call it succession. And then when Lucille dies later on, the kids are going through a probate again because Lucille's assets will be frozen, and getting judges and lawyers and courts involved to oversee that transfer of assets to the children after the surviving spouse passes away. Again, the asterisk. Pierre had an IRA, and so those are that's what I call a non-probate asset. Pierre named Lucille as his 100% designated primary beneficiary. So yes, that's handled differently when Pierre dies. Lucille gets Pierre's death certificate. She goes to the financial institution where that IRA is held. They'll move that IRA into Lucille, his surviving wife's name. No judges, no lawyers, no courts are necessary for that. So oftentimes people die with some non-probate assets like IRAs and probate assets, particularly in Louisiana, where we don't have some of these mechanisms where certain assets can be transferred outside of probate. So Pierre's home, his rental property, his brokerage account, that all has to go through the courts if Pierre left all of that in his name and relied on his will to pass that along to survivors when he passes away. So that's one way to do it, is through your will. And then the second way to do it, very, very common, is Pierre and Lucille set up the Pierre and Lucille, I'll call it revocable living trust. The idea there is assets that are already titled in the name of your trust when you die. Things that are in your trust when you die, they don't have to go through any kind of court and lawyer involved process. So only assets, probate assets that are titled in your name have to go through the courts to be transferred. So the idea is to create that Pierre and Lucille living trust, all those things that Pierre and Lucille want to happen when they pass away, all those terms get incorporated into their living trust. And then really a key point here, Pierre and Lucille's probate assets like their home and their rental property and their brokerage account, that all gets retitled as part of the estate planning process. It gets retitled from Pierre and Lucille to Pierre and Lucille as trustees of the Pierre and Lucille Trust. It doesn't put any restrictions on Pierre and Lucille's ability to manage, spend, buy, sell. But now we're titling things in a way so that it's not frozen when they die, and judges and lawyers and courts aren't necessary to effect those transfers after Pierre and Lucille pass away. So if they do set up that living trust and they what's called fund or transfer assets to their trust, what happens is, under the way we talked about it, when Pierre died, Lucille wouldn't have to do anything. She would just stay in charge of the trust. Nothing gets frozen. Everything's for Lucille. She doesn't have to retitle anything. It just stays in her trust. She's the trustee and she can do whatever she wants to with it. And then when Lucille later dies, their son Claude, as the successor trustee of the Pierre and Lucille Trust, if he needed to sell their house, he could do it the day after Pierre and Lucille died, not waiting on courts to order that assets be transferred. Once he gets Lucille's death certificate, he can go to the brokerage firm or financial institutions firm and start dividing that money up three ways. Doesn't have to go hire lawyers and go through a court process, which may take 6 months, may take a year, may take longer, and it's going to cost probably tens of thousands of dollars. So all that probate expense and delay and hassle gets avoided when people set up their living trust and fund or transfer assets to their living trust in the right way so that everything's titled appropriately. So they're like, we don't like the idea of having to go through courts when we pass away and having to hire lawyers. No offense, Paul, is what they always tell me. But yeah, we'd like to set it up to make it as easy as possible for them. We'd like to set up that living trust. So that's what they did. So their living trust got set up. Whenever someone does have a living trust, they also have a will. Mind you, their will may never be used, but because the trust controls the disposition of everything. But sometimes people, mistakenly or otherwise, they get their trust, but they die maybe 20 years later, and there's an asset in their name. It might be a brokerage account. It might be a piece of real estate that they acquired. They kind of forgot that they should have acquired it in the name of their trust, but they acquired it in their name. And so when people do have a trust, they often have a will, and the slang term for that will, when people also have a living trust. It's called a pour over will. Pierre's will has the effect of saying something like, if I die with anything in my name, then I want it to go to my trust when I die. And then that probate would be necessary to transfer that asset from Pierre's name into his trust. So the whole idea is get your trust set up and get things titled in it correctly, so that when you pass away, there's nothing in your name that requires that pour over will to be used, that requires that probate proceeding, because your trust is set up and it's funded properly. But we always have that kind of just in case will called a pour over will. In addition to their trust that they'll have, we'll call it a joint trust, and then each of them will have their pour over will. They'll also each have their, I'll call it, some people call it financial power of attorney, some people call it general power of attorney, some people call it durable power of attorney, some people just call it power of attorney. So that's that instrument that if Pierre gets incapable during his lifetime, he's got Lucille and Claude as the backup to Lucille to be able to kind of act for him in case he can't act for himself. And then we also we have, living will laws. Living will, people get all confused about the term. There's will, there's living will, there's living trust. Living will, a lot of people sign living wills. It's a statement about life support machines. So the healthcare power of attorney governs, you're in a surgery, you're not on life support. You're not a vegetable with no chance of recovery. You just can't make your own medical decisions. So the healthcare power of attorney is where, you state who you'd want to be able to make those decisions for you. The living will is really where you make your own decision. Typically, you don't appoint people in a living will to make a decision. With a living will, you make your own decision, usually expressed something like, if I'm ever in that profound vegetative state, there's no chance of recovery. The machines are serving only to artificially prolong the dying process. By signing a living will, you're saying, if I'm in that situation and that I'm making my own decision here, directing my family and doctors to honor it, I want those life support machines withheld or withdrawn, but I want the medication to be comfortable. So, there's a discussion about that. That's part of the estate planning process. Okay, so that's what they kind of wind up with, and then there's a bunch of information gathering, a bunch of family information gathering. There's all the documents that get prepared. There's reviews that take place. Once everything's 100% perfect, then Pierre and Lucille have to sign everything in the presence of the appropriate notary and witnesses. And transfers of real estate documents get recorded in the land records. Um, and then, at least in our case, all the hard copies of everything go into Pierre and Lucille's estate planning portfolio. An electronic version gets uploaded into a vault that Lucille and Pierre would share with us, so we can monitor assets and enter documents. And then it's a matter of kind of staying in touch over the years. I would say there's probably about a 90% chance that they won't change any of their legal documents in the future, because what they did is probably not going to change. I mean, those decisions they made leaving it to the three children equally, appointing Claude to be the person to handle that when they both pass away. So yes, they may buy and sell assets over the years, but I don't need to, no new legal documents need to be prepared when they buy and sell new properties or vacation homes or investment accounts. They just need to make sure that those assets are titled in the name of their trust, so their trust will govern the disposition of it when they pass away. All right, so let me go back. Let me go to some of the chat here and see what we've got. So this is awesome. We've got um, a question or answer. Let me see if I go and look to the top. Okay, financial Vanguard. If one of us dies, all we have to do is send a copy of the death certificate. So Linda, that's what Vanguard's telling you, and so what you have at Vanguard must be able to be transferred when you pass away with a death certificate. So what you have at Vanguard is, I call it a non-probate asset. Probably have IRAs. You may have brokerage accounts, and maybe you have TOD or transfer on death beneficiary designation forms prepared. So I'm guessing, of course, I'm guessing on all this stuff, but that's probably what you have at Vanguard. And so, yeah, those uh, when you can set things up so that all that probate stuff is avoided. And look, different states have different rules. Most states have rules where you can set up a transfer on death, TOD on your brokerage account, POD, payable on death, on your bank accounts. Some states, if you own a vehicle, you can register it so it automatically goes to someone when you pass away. You can register it that way with the motor vehicle office. Some states, even if you own a company, you have a membership interest in a limited liability company or LLC. Some states enable you to arrange that so it gets transferred on down to one or more people when you pass away. So more and more legislation is being created in the different states, enabling people to be able to entitle things in a way that avoids probate when they pass away, and that's probably consistent, Linda, with what you've got. All right, daughter-in-law is a fiduciary, however, is a fiduciary. That could mean a bunch of different things. However, since we have issues between us, is there any way she can be instructed to stay away from my home when I'm gone? Yeah, that's one of those unique circumstances that I mentioned earlier. So what I'm thinking is, um, from a legal perspective, I could see having that home and the belongings in a trust, having someone other than daughter-in-law as the trustee of that trust to handle things when you and your spouse pass away. So that right there, legally, daughter-in-law is not involved in anything with that house and belongings. You've all kind of heard the saying of possession is 9/10 of the law. So I don't know if ingrained in your question is what keeps my daughter-in-law after I die from she has the key to the house or she knows how to get in the window, what keeps my daughter-in-law from being able to go in my house and get personal belongings? That's another story, but from a legal perspective, I'd say having that house in a trust, daughter-in-law, not daughter-in-law, someone other than daughter-in-law is the trustee of that trust when you die and has all the control and management and say so and can kind of keep the daughter-in-law out if they have to. All right. Hey, Ann, wait, I remember your see, I haven't done these videos in months. I've been busy doing some traveling and stuff, but good to see some of the same people here. Ann, T, especially. I had family convince my mother to disinherit me after they realized how advanced her dementia was while I was caring for her. I'm devastated. Okay, yeah, that's a tough one. So, there's always 2 sides to every story, of course, and so 504 inputs. Um, it's a tough one because, I'm not saying this is the case, it may be in your situation, but sometimes children do influence their parents into doing something, and then the parent dies, and maybe a child is excluded, and maybe you kinda know that your mother was influenced or that your mother had dementia. There's no way she could have known what she was doing, but it's hard to prove that. So it's a tough one. So, yeah, those are tough situations. What if your adult child is irresponsible and your planned executor just passed? Can institutions handle it? Yes. Had a conversation today. All right, parents, when you pass away, do you want, and let's see in your case, um, do you want an individual to be the executor of your estate, or do you want a corporate trust company? All the big financial institution firms, we've talked about Vanguard, Fidelity, and Schwab, they all have trust companies, and so do a lot of other financial institutions have trust companies. So yes, it is possible to have a, as you call it, institution handle the settlement of your estate. Of course, all that has to be planned in advance. All right. Yep. And thanks for there. And it sounds like under influence by your family and your mom said, yep, it's been a long time. LD, my man LD, or I don't even know if LD is my person LD. Good to see you. That's a blast from the past too. It's been a long time. Sure has. Got here late, so we'll listen to the replay. Hey, yeah, good. Hi, Larry. Yeah, LD is Larry. Yeah, Larry is my buddy, Larry. So hey, Larry. And there. Okay, so there we go. All right, just getting cranked up. I'm getting back in the spirit. Uh, I'm in town. I'm available, and so we start cranking these out. I'll put them on the schedule ahead of time so you can check it. I'll tomorrow morning. I'm gonna put some on the schedule, so hopefully you can check out my page and see some of the live streams that are scheduled. Thanks so much, everybody. This has been great. I've enjoyed it. Thanks for your cooperation. We'll see you next time.